Hello?
Hi, perfect. Thank you so much. All right. Good morning, Ms. Campbell. How are you?
Good morning.
Good. So we are going to get started. I'm Parole Officer Tricello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Shauna Campbell, inmate number 420120. Today is Tuesday, January 7, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and York Correctional Center. Can you please state your full name and inmate number for the record?
Shauna Campbell, 420120.
Thank you. This is a public hearing, and public access to this hearing is available via video live stream. And present this morning is Attorney Sirica. Can you please identify yourself for the record?
Sure. Attorney Alfonzo, Sirica, Public Defender with the Parole Revocation Unit on behalf of Ms. Campbell.
Thank you. This is a preliminary hearing which has three purposes under Connecticut law. The first is to determine if there's probable cause to believe you committed an act that violates a condition of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there's probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you, and this hearing is being recorded. Also, the testimony at today's hearing would be taken or will be taken under oath. So, Ms. Campbell, can you please raise your right hand? You solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury.
Yes, ma'am.
So we're going to go over the procedure for the hearing. First, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. I'm then going to review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you'll have the opportunity to address the issue of probable cause and the severity of the allegations. And at the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose of procedure before we begin?
No, ma'am.
Okay, so you do have important rights to this hearing, and I'm going to review them with you now. You have the right to an attorney, and counsel is present here for you. You also have the right to receive written notice of the charges of violation. Did you receive the written notice?
Yes, ma'am.
You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case, and you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, ma'am.
So we're now going to review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. So on charge number 1, condition of legal obligation, the charging officer reported that as of 12/20/2024, when you were remanded back to York CI, you were not registered for DWOR, the Deadly Weapon Offender Registry. You were given the DWOR advisement March 2023 prior to being released on community release, September 2023 prior to re-release following top remand, and again December 2024 prior to discharge of special parole. To this day, you have yet to comply with the DWOR ordered by the court, as no active is documented in collect. During any review since March 2023, and the Connecticut State Police were also contacted and confirmed the inmate did not register. On charge number 2, condition of drugs, the charging officer reported that on December 19, 2024, on or about this date, you used cocaine and rendered a positive urine for cocaine and THC. Based on your actions, you were in violation of release direction, obey all laws. On charge number 3, condition of halfway house placement, the charging officer reported that on December 20th, 2024, you exhibited aggressive sexualized harassment behavior towards another inmate resident at Rise Halfway House. This violated the space of the other offender, and she reported feeling unsafe and uncomfortable. This is a violation of Halfway House Agreement number 7. I will treat others with respect and not engage in verbal or physical altercations with other offenders, staff, or third parties. On charge number 4, condition of mental health evaluation and treatment, the charging officer reported that as of 12/20/2024, you had not completed or made an attempt to schedule a mental health evaluation. Your failure to do so is a direct violation of your special parole additional conditions. The state has also filed the following exhibits pre-marked for identification purposes as Exhibit A, the signed statement of understanding and agreement of Connecticut conditions of special parole. Exhibit B, the Connecticut Board of Parole remand to custody order. Exhibit C, the notice of parole violation. Exhibit D, the parole violation report. Exhibit E, the notice of parolee rights. Exhibit F, the halfway house agreement. Exhibit G, the RISE Women's Program Residential Handbook. Exhibit H, the halfway house incident report from 12/19/2024 for notice of positive cocaine use. Exhibit I, the voluntary admission for positive test results from December 19, 2024, cocaine and THC use. Exhibit J, the halfway house incident report from 12/20/2024 for inappropriate sexual harassment towards another RISE resident. And I have modified Exhibit J. I also included the 2 written statements as Exhibit J. Council. I'll go back to that. So Exhibit K is the Board of Pardons and Paroles with written decision form from 8/18/2023 hearing date. Exhibit L is the text messages, 3 pages. So those 2 written statements.
I have a question regarding, that's fine, I have a copy.
Okay.
So the first one you have, I believe is my client with a signature with a date 12/20/24.
Yeah.
Statement number 2, do you see any date on there? Do you have a date on that statement? That's the one that begins with to whom it may concern, right?
Correct. I did not see a date.
There's no date on there, correct? Okay.
Okay, so those are the exhibits that the state has provided. I have not received any exhibits from the defense at this time. Is that correct?
That's correct.
Okay. Do you need any time to submit?
No.
We have no witnesses today, so at this time it is the defense's opportunity to calling witnesses and testify with respect to probable cause.
Yes, regarding charge number 1 under legal obligations, I'm asking that a no finding be made. I do not have, nor do I see any evidence that was presented by the state regarding that charge. It just indicated some point, and not even the exact date, it just gives a couple of months, not even a specific date of when she was advised regarding this registration. And I'm looking at exhibit A through L, or maybe one other one, because you added those documents. I don't see any evidence presented in support of the under legal obligations. So I'm asking that a no finding be made on charge number 1. Charge number 2, my client does admit to that. She was indicated to her that she would be placed in IOP because of the test, and obviously that then occurred as she was remanded on that same date. Under charge number 3, under halfway house placement, I'm also asking that a no finding be made on that. That charge deals with December 20th of 2024 is where the allegation is that my client exhibited aggressive sexualized harassment toward another inmate resident at RISE. Exhibit L is some text messages that go back and forth between my client and I'm gonna just put her, the other person's ES. I don't want to put her name on the record. And in reading these multiple times, I don't see anything here that's aggressive sexual harassment in these documents. It's my client and the other individual kind of going back and forth. On page 2, although there are no dates on there, I believe about halfway down, I'm not sure if yours looks a lot darker. I see Wednesday listed, and I'll give you a copy of mine. Yours is darker. So although it doesn't give a specific month and date, it does have Wednesday on there. You can clearly see that, I hope, correct?
Yeah.
Okay.
Okay.
And if I may have it back. So the reason why I'm asking that no finding be made. So my client is remanded at approximately that time. December 20th of 2024 is a Friday. I'm assuming this is from Wednesday the 18th, so 2 days prior to my client being remanded. This is the back and forth text and subject, obviously. I read this multiple times. It's kind of general conversation back and forth where the other individual is responding to my client, questions and then kind of going back and forth. So I'm asking that a no finding be made on charge number 3. Charge number 4, I'm sorry, could I have, I don't believe you put Ms. Campbell. You did?
Yes.
All right. So Ms. Campbell, on charge number 4, the parole officer indicated that you didn't complete nor make any attempts to schedule a mental health evaluation. Can you please let the hearing examiner know what attempts, if any, you made and how it went about for your mental health evaluation?
When I got to Women Rise, Officer Sheehan told me that she was recommending that I go to Ford Clinic in New Haven for mental health because they do one-on-one, they do medications, they do groups. And within a day or two, I attempted to call them to schedule an appointment and the number was disconnected. I made mention of this to my case manager, Ikeda Gibson, and she said that she would look into it for me and get back to me. I didn't know that there was a timestamp on it. Otherwise, I would have sought other ways of going about it. But I did make multiple calls to Ford Clinic and the number was disconnected.
And that number being disconnected is, you just testified in what you previously told me. You brought that matter up to the case manager and what was her name?
Ikeda Gibson.
Ikeda Gibson, and you told her you were having difficulties scheduling your mental health evaluation.
Yes, she said on her next day off, she would go down to the Ford Clinic because multiple people were having an issue getting in contact with them, and she would go down there and find out what was going on with their phone.
Okay, thank you. Those are my comments regarding these charges. I know this is a preliminary hearing where probable cause has to be established. Then the second prong is it serious enough that my client should be held pending a revocation hearing? And I am submitting to you these, if you were even to make findings on all 4 of these, this does not rise to the level where my client should be incarcerated. Number 1, once again, charge number 1 on the legal obligation, the state has presented 0 evidence to back up that charge. Number 2 is an omission, is dirty urine. Charge number 3, once again, under the halfway house placement, that text messages in no way, shape, or form is indicated any hostility between my client and ES. And on charge number 4, my client, their testimony, she did make an attempt. The number was disconnected. She did bring it to her case manager's attention. It's not like she didn't just blew it off and didn't do anything. She made more than 1 attempt to schedule that appointment. Thank you.
Thank you. So I'm just going to take a moment and I'll let you know my findings. So I'm going to announce my findings. So I'm going to make a no finding of probable cause for charge number 1, condition of legal obligation, as the state did fail to submit sufficient evidence in support of the charge. I am going to make a finding of probable cause on charge number 2, condition of drugs, based on state's exhibit A, D, H, and I. I'm also going to make a finding of probable cause for charge number 3 for halfway house placement, based on state's exhibit A, D, F, G, and J. And I'm going to make a no finding of probable cause on charge number 4, condition of mental health evaluation and treatment as deemed necessary, as again, I feel like the state failed to submit sufficient evidence in support of the charge. So those are the findings that I'm making today, and I am going to find that the acts are serious enough to warrant revocation. So I've determined that you'll remain detained while you wait your revocation hearing, and the records department and your parole officer will be notified. At your revocation hearing, Ms. Campbell, myself or another hearing examiner will determine if you violated the conditions of your parole, and if so, the hearing examiner will make a recommendation regarding whether your parole should be revoked and if any sanctions should be imposed. Do you have any questions right now, Ms. Campbell?
No, ma'am.
Then you're all set. This does conclude the preliminary hearing, and I'm going to the record.
Shauna, I'll set up another call with you once I get the revocation date. As I indicated to you, it has to be within 60 business days. So once I get the date, I'll set up another call with you. And as I also indicated to you, my social worker will reach out to you about your background, okay?
All right, thank you.
All right.
Thank you. This concludes the preliminary hearing for Shauna Campbell. All right, you're all set, Ms. Campbell. Take care.
Thank you.
Roscoe?